All right, this is the last of the cases that we are taking a look at for our discussion of the common law and the environment, and in particular with respect to public nuisance. In one of the other mini lectures, I looked at Missouri versus Illinois, a public nuisance case, and an earlier one, Madison versus Ducktown, which was a private nuisance case. Here, we'll take a quick look at Georgia versus Tennessee Copper, which is also a public nuisance case. But unlike Missouri versus Illinois, it involves air pollution. And unlike in Missouri versus Illinois, Georgia or the plaintiff actually won. Right? So the court did find that there was a public nuisance. The facts of the case, by the way, are an extension really of what happened in Madison versus Ducktown. Madison versus Ducktown involved acid rain, pollution from copper smelter in that particular area that harmed a private landowner. Here, some years later, the state of Georgia brought a case against the Tennessee Copper Company. The other smelting company, the first one being the Ducktown Sulfur, Copper, and Iron Company, was causing all this air pollution in that area. And this area was situated right at the border of Tennessee and Georgia. Now, in the private nuisance case in Madison versus Ducktown, this had been a state case that had gone all the way through up to the Tennessee Supreme Court. Here, because Georgia was also impacted and because the neighboring counties, as you know, of course, pollution doesn't respect political boundaries, was affecting all of the residents of 5 counties in Georgia. And the Georgia state government had been trying to get the Tennessee state government to abate the nuisance. With no success, they were in negotiations with the Tennessee Copper Company, and Tennessee Copper did some things, but not to their satisfaction. One of the things that they did do, rather than shut down the operations, was to make the smokestacks, taller. Unfortunately, that, of course, does not actually eliminate the pollution. All it does is it puts it up higher to the air currents, and the pollution would be spread a longer distance across a greater area. And unfortunately, that actually does nothing then to eliminate or reduce the acid rain. And so the state of Georgia then resorted to this lawsuit against a public nuisance lawsuit against Tennessee Copper. The harm here was fairly well established. That is, acid rain essentially killing trees, killing crops, and of course harming livestock and making it essentially very difficult or impossible for the residents there to engage in farming or any kind of agricultural activity. There was no question here on the part of the Supreme Court, unlike in Missouri versus Illinois, about harm. Right, as I mentioned, the harm was fairly obvious, and also about causation. You could observe the smoke going across, and that really, in many respects, made all the difference in the outcome of this case. The Supreme Court essentially found that causation was established, found that the causation by preponderance of the evidence was established with the evidence presented, and therefore then granted the injunction. Now note, there's an important difference here also, that unlike in Madison versus Ducktown, where the private individuals were not able to get an injunction, the Supreme Court did issue an injunction here, or allowed for that. But the role of the plaintiff here, the state of Georgia in its quote-unquote quasi-sovereign capacity bringing this lawsuit, did matter, I think, in that it changed the balancing test here. The state of Georgia was not only bringing the lawsuit in its own landowner capacity, but really on behalf of all its citizens and the residents. And if you think about that, it really had both a practical influence here, effect in that any kind of balancing it would not have considered only the narrow cost here of a landowner versus the benefit of the jobs and taxes, etc., but really the harm to everybody across those 5 counties that the state of Georgia sued on behalf of. And then, of course, also, secondly, as a quasi-sovereign here, its role in protecting the health and the environment and the resources of the state of Georgia really weighs, I think, in a dramatically different way than sort of a concrete harm to the property interest of the state of Georgia. It was suffering essentially a harm to its ability to protect its citizens and its right as a sovereign, as a regulator, were therefore impaired by the activities of the Tennessee Copper Company. So it did receive an injunction and different outcome, but also very different facts and proof. And so an illustration of how public nuisance doctrine could actually positively be used to abate a nuisance. Right? All right, I'm going to stop here, but an important illustration of the positive power of public nuisance doctrine.